Welcome back to Business Law course. Still in the discussion of intellectual property law, especially regarding patent. In this part, we will discuss about inventor and invention. These two things are the main part to understand about patent. Well, inventor is the one who created a technology with an invention, and then it should be protected by a patent. And in the beginning, at the previous part, we've read from Indonesian law that an inventor could be a singular person or more than one person. And in the perspective of law, a person could be a natural person or maybe a company. And further, when we talk about the inventor, we also should find another terminology called the patent holder. So actually the concept is quite the same with a copyright. When I am a person who has brilliant idea to invent something, well, I am maybe an engineer or a person with a qualification that able to create new things, then I could be an inventor. But the problem is sometimes I'm only a creator or an inventor and I'm lack of business capability. So that's why sometimes I need another party, a business company or a businessman to sell my product or to produce my product in numerous number, mass production. Well, actually, if I want to produce it myself, I could do that. So when I made a creation, when I make the invention, actually in the beginning I am the inventor as well as the the patent holder. Just like in copyright case, once you make the creation or the work, you are the author and also the copyright holder. But if I cannot develop it in the business territory, so I could offer it to another party to produce it. Well, then if I transfer it to others, then I transfer my position as the patent holder to the company or to the other person. If you remember the case of Dr. Robert Kearns that I actually to watch from the movie, you could determine that in the beginning Mr. Robert Kearns is the inventor as well as the patent holder, but then he led his friend Mavericks to sell it, to distribute it, to make it be more able to be sold to related parties that need the invention. So inventor and the patent holder could be the same person in the beginning, but then the patent holder position could be transferred. Though you also need to read and learn about the existence of a patent under a working agreement, just like in copyright. So if you create the invention because you work for someone else, then there would be some exception about that. So you have to read the related regulation. We don't have all the time to discuss it here, but this is the main point that you need to know. So now we're talking about invention. Just like a copyright will only be given to a work or a creation that is new, not copying others' work. If you're copying others' work, then your creation is not protected by any law. Even you could be sentenced for violating someone's right. So the invention that could be protected by the law, it should be novel or new. The new here, or the novelty here, could be something that really new, or the renewal of something that already exists. The example we will see further in the next part. And it must have inventive step and non-obviousness. Inventive steps mean, according to the expert in the area of the object, If it is motorcycle, something like automotive. So according to an expert of automotive, automotive, this kind of things is really new, never been disclosed before. Nobody ever makes something like this. It's also related to non-obviousness. Never been uh, in the assessment of an expert. It's never been there's never been something like that before. So if your creation has this kind of characteristic, so it's fulfilling at least one of the characteristic of the protected invention, and also industrially applicable. So it could be produced in industry, could be sold. So it's not something that's too difficult to be implemented. It must be something that applicable, because invention itself is talking about the mechanism function. So let's say that we're talking about uh, a pen, for example. So a pen, in the beginning, it is uh, a new invention because it was invented before people know about pen. So there is something novel, have an inventive step. Inventive step means something that applicable technically, so it can be used to what? To write. And then it is industrially applicable. It can be produced, can be sold. The ingredients to produce it, it's easy to be found. So if you made something like that, then it is an invention and it's protected by a patent. But if your creation is not fulfilling this characteristic, so it could be violating others, because if it is not novel, then there must be someone else who already have this invention. So you must be pay attention with this characteristic before you claim your patent. There are two classifications of patent. The first one we call it just patent or regular patent. The second one is the simple patent. Just patent or patent. It's given to an invention that really new. Previously I told you about a pen, right? When a pen was invented for the first time, when it means previously nobody knows about pen, and then someone invented a pen, then this pen is something that's really new. So it is protected. The invention of this pen is protected by a patent law in a form of patent. But then few years later, maybe someone make a new variation of pen, and then this pen could have new inventive stuff or new function. Let's say that you can erase your writing with the pen. So previously the pen is only to write, and then you make something new, a pen that could erase the works. So the new things that you put into the pen, it's also considered as a patent, but we call it a simple patent because you make a renewal of the existed patent. Or let's say a car. In the beginning, a car is protected by a patent, and then if you put something new in the car, like let's say that you make a flying car, then the flying car is a simple patent because actually the car already exists before. Or if you talk about a bicycle, the bicycle in the beginning is protected by a patent because of what? Because it is an invention. It helps people's life. It's a technology. It have inventive step, which is help people in doing movement. It's a kind of transportation. Previously, people should walk or maybe use another transportation, but then they have bicycle. So it is something new. So it is protected. So it has an invention. But then maybe you make some renewal, some new inventive step in the patent. Maybe you can make the bicycle become portable, something like that. So then there is an evolution in bicycle. So that's new things that you put into the existing pattern. It's a simple pattern. In Indonesia itself, the direction of the protection is different. For regular patent or just patent, it's 20 years. It means if I invent something new, then for 20 years I have the exclusive right of upon this invention. Nobody could use it without my permission, and if they want to use it with my permission, usually I as an inventor would asking for some royalty, some incentive from them. While the simple patent is only protected for 10 years. After that, this patent would be owned by everybody, so every company could produce bicycle, everybody could produce pen using the trademark, because after the duration of the patent protection, now it becomes the public domain, which is the ideal and the main purposes of the protection of patent philosophically, that the existence of patent is to develop the human's life, the prosperity of life of the universe. Well, unfortunately, because of the limitation of time and the limitation of resources, the discussion about intellectual property should be finished here. Actually, there's still more classification, and even in patent itself, we still have many things to discuss. But you have to learn it by yourself, or maybe you could join my class in law school, take the intellectual property law subject. Then we will learn about that in detail. Or maybe several semesters from now, if I teach intellectual property, I will make another video so you could access it, because there's still many things to learn about patent. Or you could read my books or another book, and also you have to learn individually about another kind of intellectual property. You have to learn by yourself about trademark, about industrial design, about integrated circuit, about trade secret, and also new plant variety. I hope you have enough spirit to learn all of them by yourself. But I think copyright and patent is two main intellectual property that you need to know as a business student. I mean business school student, because these two is the one that mostly involved in a business as well as a trademark. But you have to encourage yourself to learn about trademark independently. Well done, everybody. This is the closing of intellectual property law topic, and we are approaching the end of the semester. Stay healthy, stay safe, keep spirit. God bless you all. Ciao.